Good morning, everyone. My name is Nick Kepple, and I'm the probate judge for the Southeastern Connecticut region, which includes Groton, Stonington, North Stonington, and Ledyard. And I'm pleased to welcome you this morning to a presentation, the first of three presentations by the members of the Estate and Tax Planning Council of Eastern Connecticut. The Estate and Tax Planning Council is a group of local professionals with a mission to educate its members and to inform the community with outreach programs like this on recent changes in estate planning and estate tax law. This morning, I'm pleased to be joined by two excellent attorneys from the region, Joe St. Roch from Hoops and Associates and Daniel King from Lahan and King from Norwich. Today, we're going to be talking about two topics, both of which involve key estate planning activities. The first topic will be the all-important exercise of preparing and executing a will, which expresses your intentions about what you want done with some of your assets. And then the second part of today's talk will be about once that will is done and someone passes away, the estate is administered by the probate court, where I get involved. And so the second part of the talk will be about the administration of someone's estate in the probate court. So without further ado, we can commence the discussion of wills, which I believe is going to be led by Joe St. Roch. Joe?
Yes, thank you. As Judge Kepple stated, having a will is very important. The first thing I'll do, and then Dan will, Attorney King will continue the explanation of why a will is so important. First off, what does it do? A last will and testament, which the will, when you say a will, it's short for last will and testament. That's the official legal title. They're the exact same thing. A will, the purpose is to provide instructions to the probate court and your surviving relatives of who receives your property after you pass away. And doing a will, I have some clients who feel that doing a will is avoiding probate. That's not the case. For information about avoiding probate, I would encourage you to watch sessions 2 and sessions 3 of this Demystifying series. That's not the purpose of this discussion. The purpose of this session is to talk about the basic wills and the probate process. I think the majority of people in Connecticut end up going through probate. It's difficult to avoid probate for all of your property, and in a lot of cases, it's not very desirable. But like I said, more information on that in subsequent sessions. So the basic function of the will, like I said, is to tell the probate court what happens to your property after you pass away. And every state, including Connecticut, has an intestacy law, which is basically a default law to where the legislature is determining what happens with property of a deceased individual if they do not have a will. So if someone dies without a will, intestacy law kicks in, state of Connecticut legislature says, this is what happens with the property. And I have no doubt when the legislature crafted that law, they had the best intentions. In general, it's dividing property among your closest living relatives and your spouse in certain percentages. That being said, the intestacy law does not work for everyone, or perhaps even the majority of people. Your wishes may be different from the Connecticut default law. So it is always better for you, the testator, to determine what happens with your property, rather than leaving it up to the Connecticut default law. It's a catch-all for everybody, but it's not specific to your needs. It's just a general default law. Also, with a will, you get to determine who is put in charge of your estate, who's in charge of settling your debts, making sure your property is either sold or transferred to the proper beneficiaries. You get to decide who's in charge, who the executor is, and also a lot of times who the backup executor is in case your primary is unable to serve. If you don't name an executor, then the judge of probate has to decide. And again, the judge of probate, they have the best intentions, but they don't personally know your relatives. So again, it's better for you to make that decision in your will. Finally, if you have minor children under the age of 18, you get to determine in your will who their legal guardian is. And I know that's hard to think about, but if you pass away leaving minor children, it is a lot better for you to decide who their legal guardian becomes instead of a family court or a probate court having to decide. And with that, I'll turn it over to Dan for some other aspects of wills.
Yeah, thank you, Joe. Yeah, so I want to kind of expand on, why most people need wills. With new clients, I get asked that question all the time. Why do I need a will? Why can't, the default rules just apply to me? One of the biggest misnomers, I think, is that estate planning and wills are only for those who are retired or entering their golden years. It really does affect all stages of life, because the policy behind having a will is really to avoid unintended consequences of your assets passing outside of your wishes. A will allows you to ensure that your loved ones are taken care of, or those specific individuals that are important to you, or even those charities, religious organizations, or other benevolent organizations are taken care of in your memory and according to your wishes. It's outside of the topic of today, but a will can also, when properly drafted, provide protections and benefits for estate tax planning purposes. It can provide planning for special needs family members or disabled family members. So there's numerous benefits towards planning towards the future and when you're not here. Joe touched upon the rules of intestacy. So the rules that apply in having your assets pass if you do not have a will. It's really not uncommon for unmarried individuals who have been together for a very long time. For all practical purposes, are in a relationship just as equal as a marriage. But for legal purposes, they aren't married, and under the rules of intestacy, that person is not protected and would not share in any inheritance. An issue that's commonly dealt with are second marriages, or relationships where people have children from previous relationships, and balancing how you want to provide for your spouse or significant other while also providing for your children of previous marriages or relationships. One thing that's really shocking to a lot of people is under the rules of intestacy, a surviving spouse does not necessarily receive all solely owned assets of their spouse. I've dealt with situations where an elderly parent was still living, and without a will, that elderly parent actually would share in a portion of the probate assets. The will also allows for planning for minor children, as Joe touched on, naming guardians. Without a will, those children receive assets at the age of 18, and sometimes that is not beneficial to their long-term financial well-being. So you can set it up so that they receive assets at a later date in their life. You know, and I've also dealt with planning for family businesses. You know, perhaps there are multiple family members involved with a business or a farm. Certain family members are more involved than others, and perhaps you don't want assets to be divided completely equally, or you would like business assets to pass to one individual, while you know, other assets or liquid assets pass to those who are not involved with the business. So there, you know, there's all types of families, and there's all very unique situations. And without a will, you don't have the ability to direct what will happen after you pass away. And one of the more messy issues I've dealt with are people who've been recently divorced. Sometimes after a divorce, people allow their financial affairs to not be in as order as they were during marriage. And if there's an untimely death, it can cause some very serious negative consequences. So these are all areas that are, you know, sometimes difficult for families to want to think about or embrace. But in doing so, you can plan for every contingency. You know, Joe and I sometimes call ourselves the worst case scenario guys, because we have to think of all the worst case scenarios of unexpected deaths or unexpected consequences. But it's, you know, in the event that that were to occur, it is important to have those protections in place. So I'm going to turn it back to Joe, and so Joe can talk about some of the procedural benefits as well.
Thanks, Dan. So yes, once someone actually passes away, the will is admitted for probate, and more on that in a few minutes. And the executor is appointed, and the executor is doing their job of administering the estate. Once that happens, having a will does continue to make the executor's job easier. The will, a typical will give the executor certain powers that they do not get under Connecticut law without a will. For example, the power to sell real estate without obtaining probate court permission first. That may not seem like a big deal. Oftentimes, clients end up having to wait an additional 30 days, even after they get the probate court permission to sell the property, because there's a 30-day statutory appeals period. And some buyers' attorneys insist on waiting that appeals period. So just having a will can save 45 to 50 days or even more of real estate taxes and in homeowners insurance and electric bills that the executor otherwise would not have to pay from the estate property. So that's just one example of how having a will makes it easier for the executor to do their job. There's also a few other things, more minor details. One is it waives probate bond. So probate bond is, I'll just say, if there's no will, the administrator of the estate, which is the same thing as the executor but without a will, the administrator has to get a probate bond policy from an insurance company. And the probate bond insures the estate against the administrator being negligent with the money or committing malfeasance, for example, taking the estate funds and going to Vegas and gambling it all away. If you trust your executor, you can waive bond in the will, and that just saves the estate from having to go purchase this bond insurance policy, which is going to run at least in the hundreds of dollars, potentially in the thousands. So just having a will, if during your life you pay to have a will done, it's going to save more than your cost of preparing the will just in avoiding that bond after your death. So even from a financial perspective, it does make sense to do it during your life. I think that concludes our discussion of basic wills. Does anyone have anything they'd like to add?
I'd just like to comment that and emphasize that to me, the major benefit of doing a will is that it provides a person the opportunity for your preferences to be honored, whether it's in the selection of an executor, a guardian, or a trustee. Because we have trust. There'll be a later session about trusts, but one type of trust is what's called a testamentary trust, a trust that is built into the will that only springs into existence when someone passes away. But in my experience in almost 10 years at the court, one of the most challenging and difficult experiences is where someone hasn't done a will, and then family and others fight about who should be the executor, who should be the guardian, who should be the trustee, and those and I am put in this position of having to decide who would be best at these different roles when you, as the person we call the testator, people are familiar with giving testimony in court. Well, a will provides you a chance to have a voice to give testimony about what your wishes are with regard to your assets. And so the person who's developing the will is best positioned. They have the best knowledge about who not only who they wish to be in these roles, but who would be best in these roles, far better than I. And so you basically put yourself in the driver's seat and don't leave it up to others to decide and far too often fight over who's going to be in these roles. And the sad thing is these fights occur when someone's passed away. So people are grieving, and then you have a fight on top of the grieving. And it can all be avoided by you expressing your wishes. And as Joe makes the great point about the amount you're saving by doing it just on the bond alone. Candidly, I'm amazed at the fact that so many people put forth a lifetime of effort to gather serious assets, and then they want to be far too thrifty, in my humble opinion, about not spending the money, a tiny fraction of what they've amassed, to do proper estate planning. And I had a case in my court where literally this person was brilliant and worth millions. They thought they were so smart that they would do their own will, which can be done. But if you don't do it right, and which this fellow didn't do, it ended up costing many, many thousands of dollars to correct the errors he'd made, because he was confident, because he was so successful in other aspects of his life, that he didn't need an attorney for guidance about this. So basically, my 2 cents worth is, don't be penny wise and pound foolish. Utilize the expertise that's available by folks like those who participate in the Estate and Tax Planning Council to get your affairs in order. Because for one thing, one of the most dramatic instances of the benefits of doing a will, or conversely, the hazards of not doing a will, we had a case in the court where someone didn't do a will, and she basically was the last survivor of her family. She had a good long life, but her husband passed, her kids had predeceased her, and so she had substantial assets. And the long and short of it was, because she died without a will and there weren't family to take under the laws of intestacy, the state distribution laws, hundreds of thousands of dollars were what's called escheated, not cheated, but escheated, basically defaulted to the state of Connecticut. Because if you don't have a plan and there's no one to take, the state takes it. And we all love the state of Connecticut, and we love the work they do on the highways and bridges and all kinds of other services. But most people would not want, significant amounts of their assets to be defaulted to the state of Connecticut just because they didn't spend the time and a few dollars to prepare a will. So those are my couple of words of words to the wise, as it were.
Yeah.
If I could, gentlemen, have any follow-on comments to the will discussion?
Sure. Yeah, if I could just add on something that Joe and Nick both touched upon is, it's not only good enough to have a will, but a properly drafted and executed will. Because I've also dealt with many wills, sometimes either self-drafted or perhaps found online or drafted by out-of-state individuals that don't necessarily cover all contingencies, or a common issue I see is that it doesn't properly authorize an executor to sell real estate or waive bond. So without the proper drafting mechanisms in place, a will sometimes will cause unintended consequences. So just something to keep in mind when an individual is looking to engage in estate planning as well.
And I would just add, if you as the testator feel that there's any possibility that someone may be disgruntled after your passing, if they're not going to receive the share that they think they're entitled to, then it behooves you to have the will prepared by an attorney, because that attorney who prepared the will and signed it with you is the best advocate for your document if someone contests your will and tries to have it thrown out of probate court. So that, like I said, that attorney is the advocate for the will, because no attorney wants to see a will they prepared and signed for somebody overturned. And the attorney can take notes and do the correct affidavit that at the time they believed you were of sound mind, memory, and judgment, not under any improper influence, etc. So that's what I would add there.
Absolutely.
Final quick point, pursuant to Dan's comment about the importance of properly drafted wills. Wills are challenged for three reasons, typically. Lack of capacity, that the person wasn't of their right mind, inadequate formalities, failure to abide by this strict rules about the how a will is supposed to be executed. So there's formalities issues, and then there's undue influence. There can be an allegation that someone was unduly influenced. One of the things that people should be aware of is, children who are more technologically savvy and can search the internet for the best will, trying to help mom and dad, they may run into trouble that if that will if they basically serve as the deputy drafter of the will, other family members can challenge the will based on the fact that daughter or son was trying to unduly influence mom or dad, and it can create problems. So it's important, there's an important benefit to be derived by having a neutral party like a lawyer who's both knowledgeable and has no vested interest in it, be the help a person draft a will. You basically, cause as we all know, when children bring mom or dad for the will consult, we all tell them you have to wait outside. This has to be just the attorney and the person, because we don't want you to be accused of unduly influencing mom or dad, because that's probably the single biggest basis for challenging wills. So I guess we'll move on now to what happens when a will has been done and someone passes away. Then it becomes the role of the probate court, my office, and to respect the wishes that were expressed in that will and to basically administer the estate. So I think Dan's going to lead us off with a discussion about how the probate court functions.
Sure. Thanks, Nick. So, the first question is, what is probate? In this context, probate is commonly referred to the segment of decedent's estates. I'm still often surprised by the number of functions that the probate court serves in our community, in terms of services for minor children, disabled, name changes, adoptions, all outside the topic of today, but for the purposes of a decedent's estate, the probate court of the jurisdiction is the residence of that person prior to their death. Sometimes it's a little surprising that not all assets of a decedent are considered probate assets. Certain assets do pass outside of probate. Those can include jointly owned assets, assets that pass by beneficiary designation or transfer on death designations. And it can also include certain assets that may be held by trusts or other legal entities outside of the name of the decedent. So the next topic is, what is probate and what is considered probate property? What we commonly refer to as probate is really decedent's estates. It's still surprising to me how the vast number of services that Connecticut probate courts provide in terms of services for minor children and disabled individuals. But for the purpose of today's topic, probate courts generally have jurisdiction over the decedent's estate probate proceedings for those who die within their jurisdiction. So, sometimes it's surprising to clients that not all assets are considered probate assets. There are certain assets, for example, jointly owned assets that pass by way of beneficiary designation or by transfer on death designation, do not pass through the full probate process, as well as certain other legal entities that may take out, may remove legal ownership of a decedent. So there, it's not an uncommon conversation to have that if and when assets are titled in a certain manner, they are not probate assets. That can lead to avoiding probate, which for certain individuals sometimes that is advantageous, but for other individuals it can lead again to unintended consequences. For example, if there's very specific planning in place, perhaps for planning for a special needs child or for planning for mitigating estate tax consequences, holding assets in a certain manner may affect that planning. I've had the conversation before that sometimes clients think, well, I have 4 bank accounts, I have 4 children, I'll just make one bank account joint for each child. But that can, if not every bank account is equal, that's going to lead to an unequal distribution. And every parent, or most parents, think all of their children will get along perfectly, but without the protections of the probate court, sometimes children may not necessarily want to share equally if they're not required to under a will or under the oversight of the probate courts. For purposes of probate, another surprising fact is, although only solely owned assets are considered probate assets, you still need to declare those other assets, jointly owned assets, or other assets that are allocable to the decedent, including life insurance or 401ks with beneficiary designations. And those still have to be declared on a Connecticut estate tax return. So even the whole concept of fully avoiding probate really isn't totally possible in Connecticut, because you still, it's abbreviated process, which Joe's about to touch upon, but there is still work that legally needs to be done within the probate courts, even when there are no solely owned assets. So with that, I'm going to segue over to Joe, and he can talk about some of the probate procedures.
Thanks, Dan. Just to add to that, clients of mine, I think both of us do real estate closings as well, and clients of ours I'm sure are often surprised when the late parent put their real estate in a revocable living trust, and then they find out that yes, you still need to do some probate work even if the real estate is in a trust. And the probate work that you have to do in that situation is what I'm about to go into. There are 3 types of probate in Connecticut. The first is called a tax purposes only estate. It involves, it's used when there are no probate assets. So there are no bank accounts in the person's name, no vehicles in the person's name, no anything in the deceased individual's name alone. And what it involves is filing the estate tax return, as Dan mentioned, reporting all of the property owned by the deceased person in any format. So in a trust, in a joint with another person, life insurance with a beneficiary designated, or a retirement account with beneficiary designated. All of that is reported on the estate tax return, because legally all of that is subject to Connecticut estate tax. Now, estate tax does not kick in Connecticut until you have multiple millions of dollars in your name. It was, I believe, 5.1 million was the threshold in 2020, and it's even higher in 2021. So the vast majority of people will never have to worry about estate tax, but the probate court and the law still requires you to file the estate tax return declaring those assets, so the probate court can make a determination that, yes, this estate owes $0 estate tax. And the reason that's done, especially for real estate, is because for real estate in particular, you need to obtain from the probate court a certificate that the court, then the judge, has certified no estate tax owed. And that certificate has to get recorded on the land records in order for your real estate to have clear title. So this applies if real estate's owned jointly between husband and wife. That's a very common situation we see, that husband passes away, wife needs to go to probate, do this minor tax purposes only probate just to get that certificate, so the real estate is now clear title and she can sell it, she can refinance it, do whatever. But until she does that, the real estate there's a cloud on title, and she wouldn't be able to sell it or mortgage it. And like I said, we regularly have to, we often see this situation years later, where the wife has come to us maybe 5 to 10 years after her husband's death, to sell the house, and we have to give her the news that we need to go do some probate, and we're happy to help her with it, but it's a surprise oftentimes that this is the case. So just keep in mind that whenever someone passes away in Connecticut, legally at least some type of probate has to be filed, regardless of how their assets are held, and oftentimes it needs to be done to clear title to real property. And I can go on to the next type of probate unless either of you have something you'd like to add. Good? Okay. So the second type of probate is called a small estate affidavit procedure. This one is used where we talked about probate assets, where there are under $40,000 worth of probate assets. So the total amount of property in the deceased person's name alone by himself or herself is less than 40,000. Usually you see when you do a small estate, you see the person had most of their property owned jointly with their spouse. Maybe they had a vehicle in their own name, or they had a small bank account in their own name. Then you do the small estate. It's an expedited procedure instead of the full estate. It still involves filing the estate tax return, so you'd still need to report all the non-probate assets. But the purpose is to quickly administer the probate assets that otherwise are frozen in place and nothing can be done with them until the probate court gets involved. The trick with this estate is there is no appointment of executor or administrator. It's solely for the purpose of dealing with those few assets that are in the person's name alone. And it's, like I said, it's an expedited procedure. And for information on the third type of estate, the full estate, which is, I think the full estate is the one that most people think of when they think of probate. I'll turn it over to Dan and he'll describe what that involves.
Right. Thank you, Joe. Yeah, so when those first two more abbreviated procedures don't apply, it becomes required to what's commonly called open probate. One must open probate when solely owned assets are either more than $40,000 or solely owned real estate is involved, not owned in survivorship. This process can sometimes feel or seem overwhelming to people, especially coupled with the fact that a loved one has just passed away, and probably the last thing they want to have to deal with is legal proceedings. But in my mind, there are benefits to probate proceedings. It does provide a structure and a timeline around transferring assets. In certain more contentious situations, it provides a structure and also a fraud protection to ensure that one's wishes are fulfilled. And it allows the executor to express their full powers, where, as Joe alluded to, that doesn't happen in the small estate procedure. And I've had experiences where individuals have difficulty accessing funds because they're not fully appointed as executor. So I'm just going to walk through the probate process and the steps in order to accomplish the full transfer of assets and the obligations of probate. The first is the application process. So there's an application to open probate. That application must be accompanied by a death certificate, and also if there is a will, then a copy of the will. That application gets sent to all heirs at law and beneficiaries, and they have an opportunity to request a hearing if they choose to with the court, if they have questions, or even if they want to object. And if they object, that leads to more of a litigation process within the probate courts. But so long as everybody understands that's the wishes of the decedent and there is no objections, then the court will appoint the named executor or the proposed fiduciary administrator. That person will be allowed to act on behalf of the estate. On the opening of probate, the fiduciary, who is an executor if there's a will, or an administrator if there is no will, is provided probate certificates with a gold medallion seal, which authorizes them to act on behalf of the estate. A notice to creditors will be posted in the newspaper, which I'll elaborate on in a moment. And the first act of the fiduciary after appointment is to start identifying all of those assets of the decedent, consolidating them, whether that's closing bank accounts, selling stock, doing other transfers, selling real estate. Sometimes the question's asked, when can I start selling real estate? Well, the day you're appointed as administrator, you can begin marketing and moving towards selling the real estate. You don't have to wait until probate is closed to sell real estate. And if business interests are involved, it may involve winding down businesses or selling businesses. So it involves really all facets of the decedent's financial interests. Once they're at a point where all assets are identified, then there must be an inventory filed with the court. Within 2 months is the legal obligation. The inventory shows all solely owned assets. So all of those probate assets that are, passing through and subject to probate. They also have to file a Connecticut estate tax return, assuming this is a non-taxable estate. It's a CT 706 NT form. And that would show all solely owned assets and all other assets allocable to the decedent. So jointly owned assets, real estate and survivorship, assets with beneficiary designation, life insurance, and other assets that pass outside of probate. So all assets on the inventory would be on the Connecticut estate tax return, but not all assets on the Connecticut estate tax return are necessarily on the inventory. During this time period, as I said, a notice to creditors is posted in the newspaper. Under Connecticut law, there's a 5-month creditor period. So creditors are obligated to present any claims of debt from the decedent prior to their death within those 5 months period. And if they fail to do so, then those debts can be extinguished, which is another actual benefit of probate. So that those creditor claims and those debts don't hang out there in perpetuity. It's an obligation of the executor to handle those debts or expenses, and to either use probate assets or outside contributions in order to satisfy all claims. And then once that 5-month period is over and all assets have been corralled, all debts and expenses have been taken care of, then once they're at a point that everything has been settled, then a final financial report would be filed with the court. This would show an accounting effectively of those debts, of those expenses, how assets have been used throughout the probate process, and then either how those assets have already been distributed to beneficiaries or how they propose that those assets be distributed. And once the accounting is approved, so long as there's no outstanding issues, the estate would be closed and all and assets could be distributed and in accordance with the court order. We're talking a lot about estate taxes. There are also sometimes income tax obligations or considerations as well. I'm not going to get too deep into that, but it's often required and often beneficial for a final 1040 individual income tax return to be filed for the decedent. depending on the time of year that they die, there's often, more of a tax refund than often expected. But that's an obligation of the executor as well to make sure all income tax obligations are taken care of. Not all estates have income allocable to themselves, but in the event they do, then sometimes a 1041 income tax return is required for the estate as well. And this can be beneficial to the beneficiaries as well, because certain expenses and certain losses can actually be passed on to the beneficiaries to their own personal tax return on the final year of filing. So, it's important to talk to a tax professional about those obligations as well, because it often leads to additional benefits. So that's the probate process in a nutshell. Sometimes there are unexpected circumstances that come up in probate. When I'm asked what's the most difficult issues of probate, and the most difficult issues are when all beneficiaries are not on the same page and do not all maybe see eye to eye. So with that, I always impress on the executor clear and proper communication. There's not a requirement that reports be sent every day or every week, but just making sure people are apprised of the status and what is going on. So the next topic is, what are the costs of probate, which is also a common question. As Joe mentioned, the Connecticut estate tax threshold now is last year was 5.1 million or so. This year it's 7.1 million. So if you have assets below those thresholds, you're not paying a Connecticut estate tax. The federal threshold's now over $11 million. So if you don't have a Connecticut estate tax problem, you're not going to have a federal problem. But that being said, it's a very political tax. It's a very contentious tax. So it's always something to monitor, because it's always quite possible that those numbers could come down greatly. The other expense of probate is, here in Connecticut, there is a probate fee. So while you may not be paying an estate tax, you will be paying a probate fee, because that probate fee is calculated on the gross taxable estate. So whatever the value of the estate is on the Connecticut estate tax non-taxable return, CT 706 NT. And that number, there's a calculation on the website. I seem to, always miscalculate it, but it's always generally around 1/4 to 1/2%. So for example, if there's a $300,000 estate, the fee is going to be approximately $1,200. Otherwise the expenses are generally, settling debts, settling expenses. You may need to hire an attorney, you may need to hire an accountant. And executors don't always take fees, but they are entitled to fees under Connecticut law. So when there's an estate that involves a great amount of work, sometimes an executor really should take a fee, because it's taking away from their own work and their own livelihood. So with that, I'm going to turn it back to Joe to talk about some of his experiences with probate and issues to digest.
Okay, thanks, Dan. First, I would just add, in terms of those of the audience who are currently executors or may have to serve in that role in the future, probably are getting the impression that it's somewhat of a daunting task to some extent. But my entirely self-serving advice for people is hire professional help, hire an attorney to help do all the probate forms and guide you through the process, hire an accountant to worry about the taxes. If the estate is relatively simple, people can absolutely do it on their own. The probate clerks are try to be as helpful as they can, but they cannot give legal advice. So if you're at all in the dark or unsure how to proceed, I would say just hire professionals, and it will make the task of being an executor much less stressful. So I think maybe what I'd like to do now is just ask Nick, do you want to talk about your experiences in terms of what problems arise in probate and how to avoid them? You might be the best person to address those issues.
Sure, and I'll do so as briefly as I can because I know we're approaching about an hour into this, and it's a lot for people to absorb. But essentially, if I had one observation pursuant to a point that Dan made, it's communication. Not surprisingly, that when executors don't communicate with heirs and beneficiaries, that can cause enormous problems. And it helps if a great deal if people try to have their affairs in order, obviously, so that it's not a humongous task for the executor and or professionals helping the executor. Yeah, the communicating with your family ahead of time or your beneficiaries about what you want to see done will and as we talked about, one of the challenges and one of the reasons why a lot of people utilize professionals, is that you're having to learn this what seems like a labyrinth in one of the most difficult times in your life, when family is dealing with the loss of a loved one. So that compounds the process. It makes the process more daunting. We do have, the probate court does have a great website. Over the years, a wonderful website has been developed that has good information. And I'd like to think that the court tries to be as responsive and accommodating as possible. We have great clerks who work in the court and the other regional courts. Yeah, I think just being trying to pay attention to what the requirements are. It's a process and it's form laden. We always talk about the probate court being a statutory court, meaning we have to strictly abide by the statutes. We don't have a lot of latitude to deviate, and the process takes typically 6 or 7 months to a year, unless there's complications. And I think it's not as daunting a process as people think it is. They think it's daunting because they're unfamiliar with it. But if you in its segments, the inventory, the tax return, and then the financial report. And lastly, I think probably one of the biggest challenges is people misunderstanding that they think that all of their assets are probate assets. What the probate court deals with is solely owned assets, but you have to report the interest you have in other assets on the tax return. So it's apparently confusing because we're dealing with both solely owned or also known as probate assets and taxable assets on the tax return. But people don't realize that when they're doing a lot of ad hoc estate planning when they name a beneficiary on an insurance policy or an IRA, or they add someone to their bank account. And part of the whole benefit of estate planning is that all of those designations and how you hold title in various assets should be coordinated and thought through in order to achieve whatever goals you're seeking with regard to a distribution of your assets. So that's all I have. Joe or Dan, anything else you want to say to wrap up?
Yeah.
Oh, sorry. Go ahead, Dan.
No, you can go ahead, Joe. Sorry.
I'm just going to put the final slide up, and the last thing, just one more time with our contact information. And I am sure that any of the three presenters today would love to hear from any of you in the audience regarding estate planning or probate administration. Feel free to contact us. And just finally, I find that the probate problems typically arise when there's difficult assets and difficult beneficiaries. So like we discussed earlier, if there's difficult beneficiaries, if there's issues among beneficiaries, you really want an ironclad estate plan to try to address those problems before you pass. If it's likely that people are going to be fighting in probate, you want the will that you want it buttoned down and all done correctly so no one can really contest it. And then if there's difficult assets, just briefly, I had a client who invested most of his wealth in a private hedge fund up in Boston, and it took his children the better part of 2 years to actually unwind that. He wasn't particularly wealthy. I think maybe it was just a friends and family thing that he invested in, but it ended up being a bear for his children to unwind after he passed. So things like that, where if you can anticipate difficulties in unwinding certain assets, those are things to discuss with an estate planning attorney and see if you can address those as well. Dan, do you have anything else to add?
Yeah, and I fully agree with your comments, Joe. Just broadly on the topic of wills, it is all about avoiding unintended consequences. There is a lot of information out there about probate avoidance, but in my experience, I've seen probate avoidance go very wrong, and it can lead to unintended consequences. And the probate process is daunting, particularly when coupled with the loss of a loved one. But it does exist to provide structure, to provide, and even to provide safeguards for the beneficiaries, as well as those with interests in the estate. And in my experience, the probate process really does work in making sure that one's wishes are fulfilled. And the other point I just wanted to make is I think it's very, very important that people update and review their estate plan on all life events, good or bad. I commonly see people in the positive parts of their lives, getting married, buying a house, having children, retiring, come into to make sure that their wishes are updated. But what can fall through the cracks often is those less desirable parts of life, such as going through a divorce or losing a loved one unexpectedly. And when those events occur, it is very important to make sure your affairs are still in order, because I've seen those scenarios go very bad as well. So it does seem like a daunting task to those who are engaging estate planning, but with the proper guidance and with the proper mechanisms in place, it's not insurmountable. So that's all I have.
So in closing, I'd like to thank the Estate and Tax Planning Council of Eastern Connecticut, in particular, Attorney St. Rock and Attorney King for donating their time today and to prepare for this. And special thank you and shout out to the Mystic Seaport and to Christopher Freeman in particular, without whose assistance the taping of this presentation would not be possible. So thanks to everyone for contributing to helping the community become wills and probate. And there'll be 2 other sessions as well. Thank you. So in closing, I'd like to express the Estate and Tax Planning Council of Eastern Connecticut, who's sponsoring this session, and in particular to Attorneys St. Rock and Attorney King for donating their time today and the time it took to prepare these presentations, and also especially the Mystic Seaport for making the taping of this, facilitating the taping of this session, and to Christopher Freeman, the Director of Development, who facilitated today's session. It's both the Estate and Tax Planning Council and the Seaport are obviously committed to having people be informed about the benefit of estate planning, and we thank them for their support.